Good day. My name's Charles Swift, and I'm the director of the Constitutional Law Center for Muslims in America. And today, I'm going to talk about the Supreme Court's recent decision in the President of the United States versus the state of Hawaii, the so-called travel ban case. The court announced its decision today in a 5-4 decision that was disappointing, but I'm going to stress not devastating. The court upheld the travel ban. To understand this decision, the first thing we have to understand is what the travel ban being considered by the Supreme Court was. The travel ban was not the first one that resulted in mass protests and the detention or the refusal of people who had permanent residence status or other status in the United States to return to the United States, nor was it the second one that the president referred to as the light travel ban. No, this was a third one. And the third travel ban existed only to 8 countries in the end: Iran, Libya, North Korea, Syria, Venezuela, and Yemen, and Somalia. That travel ban has actually been in effect since December. In December, the Supreme Court lifted the ban and allowed it to go into effect while it considered the legality. Today, Neil Katyal, who argued the case on behalf of Hawaii, pointed out was very narrow. And while disappointing, not devastating. First part was that the petitioners had challenged it, or the Hawaii, along with others in the case, had challenged it based on 2 primary grounds. One was statutory grounds. They said that the president, under the Immigration Naturalization Act, had exceeded his statutory authority. That was a hard argument to make in process on it, and the court ultimately did not accept it. At least 5 justices did not. And that's because historically presidents have issued travel bans. Jimmy Carter issued a travel ban against Iran. Ronald Reagan issued a travel ban against Haiti, etc., in emergency circumstances. Now, no president has gone as far as President Trump had. In other words, 8 countries, and in not where we had the same sort of absolute emergency powers. And that was the petitioner's argument, that this was a step too far. It was beyond the statutory authority. The court, however, found broad statutory authority in the language of the statute, and without passing judgment as to whether this was a good idea, the court agreed that the president had the power to implement these kind of measures where he had engaged in the kind of fact-finding that ultimately underlied the travel ban. The court was important to say that these had been based on security concerns that were articulated in the final executive order, something that had been absent earlier, that had looked through specific parts on whether there was adequate vetting, the actual presence of terrorist organizations and the likelihood that visitors or other could not come in it, and a catch-all provision that was the travel ban from any of these countries is not absolute. The travel ban from the countries does permit visiting under certain circumstances when guarantees are there. So it's not an absolute ban, and it's supposed to be reviewed. Now, under the administration one is, this may stay in a place for some time as an executive order, and I urge those who disagree with the president's security concerns to become politically active. The second part, though, actually gives a great deal of hope. First off, the other challenge was under the Establishment Clause, that this was in itself anti-Muslim. The government's first argument was, well, nobody has standing to bring that argument. That would have been a devastating decision if the court had determined that no one had standing and that the president could do something anti-Muslim and no one could sue him for it. The court did not determine that. In fact, the court clarified an earlier ruling that dependents, persons who had family relationships of people who weren't even in the United States, could bring this suit under the establishment grounds. They also could consider the statements made by the president. That's the good news. And so it makes clear in the process that being anti-Muslim as a singular reason will not fly under the Establishment Clause. There are those, probably in this audience, have heard arguments that the Establishment Clause doesn't apply to Muslims because Islam isn't a religion. The Supreme Court, again, they've done this before, didn't even dignify that argument. They simply applied the Establishment Clause to Islam, which is exactly what they should do. That argument isn't worth dignifying. It's a foolish argument made by people who are prejudiced, and it has no basis in law. The other part was that the court was clear to those who were worried that Muslims might be put in concentration camps or things like that. Well, the court was clear to get rid of that idea. The long-standing precedents for such national security or group classes is the infamous decision in Korematsu, which occurred during World War II. The court made clear that if Korematsu, they said it had no relevance to people coming into the country from foreign countries, but to the extent that it does, in reply to the defense, Korematsu is overruled. To the extent that we need to say that, it's overruled. There is no authority to place people into concentration camps or to round up Muslims under any idea on that. And if anyone would be emboldened by the Supreme Court's decision that now we can go after Muslims, the Supreme Court was very clear that that can't be a reason. Professor Katyal is absolutely correct that it's a very narrow ruling just to the facts of the case. And as the court pointed out, the executive order never mentioned the word Muslim. And in fact, it did not contain exclusively Muslim countries, something that differed from the first two orders. In other words, they looked more broadly at national security concerns. And it would be difficult to argue that, as they said, that facially, that they did not in any way put forth Islam. They did, however, say that you can still challenge. And the president's statements could be there, but the bad news is the level of review is rational basis. That means that if there's a rational basis for the government's stated reasons, e.g. there's security concerns in those countries, then it may be upheld. And so what this decision does is give President Trump upholds his current ban, and it could expand if he could articulate real national security measures in other countries. The good news is that if it's based on Muslim or based on that rhetoric, the president is going to find himself in a difficult position because the Establishment Clause clearly applies. It's also good news in standing in a lot of cases that we're involved in because it provides us a clear way to challenge other procedures and bring those challenges forward meritoriously. The government's strategy over the last 15 years has notoriously been the Guantanamo Bay strategy. They try and enact executive orders, policies, and principles that are beyond review of the courts. So the fact that the court reviewed this and heard it and then considered the merits of it is a significant victory. But we can't say that it's unprincipled or devastating to Muslims. It certainly isn't the version of Plessy versus Ferguson, which allowed separate but equal, or the Korematsu decision that allowed indefinite detention. It's decided on much more narrow grounds. If anything, it gives us a roadmap on how to work and how to work harder and smarter. I think we should be disappointed with the decision, but not discouraged in the overall fight. In the overall fight, there's a roadmap now. It's evolving on how to fight this, and the basic principle that Islam is protected by the Establishment Clause is clear. Thank you for watching. If you have any questions or you believe that you're being discriminated against or have difficulties with travel, please don't hesitate to contact us. The best way to contact us is to visit our website at CLCMA.org. There you can fill out a request for assistance and we will get back to you. Thank you very much.